So, this time I have chosen the title The Right to Family Life. I would like to start with the saying that everyone has the right to his or her own way. Every human being has the right to live his or her family life according to his or her wishes, needs, ideas. Respect for freedom of individual, for the autonomy of the will, and for the right to family life stems from natural law theory and is guaranteed by the state or international human rights treaties and national constitutions and law. The right to family life is not only abstract principle or value or empty shell. It has its own unique content dependent on the will of the person, which must be protected by the state. But in relation to the autonomy of the person's will, the state has particularly negative obligation not to interfere into his or her family relationships if they are functioning, if they are fulfilling their functions. However, if the family doesn't fulfill its functions or not fully, if it's threatened or at risk, the state must also positive roles, fulfill also positive roles. It must be added that if the person is bound to someone, whether by marriage, civil partnership, or de facto relationship, or parenthood, family solidarity and some restrictions must come into play in private law, in public law. And the question is how the state or national legislators should reflect these seemingly contradictory values. Here you can see the legal concept of family and the protection in the Czech Republic, in a Charter of Fundamental Rights and Freedoms as a part of the constitutional order provides protection to the family as such without specifying it. Indeed, like the Convention for the Protection of Human Rights and Fundamental Freedoms. These documents protect family life in general, and as I mentioned before, everybody has the right to family life according to his or her choices, needs, and so on. Regarding the civil code, it is provided in its book 2, the general part that private law protects the dignity and freedom of an individual and his or her natural right to pursue his or her own happiness and the happiness of his or her family or people close to him or her in a way that does not unreasonably harm others. And secondly, private law primarily relies on the following principles. Everyone has the right to protect his life and health, as well as freedom, honor, dignity, and privacy, and family, parenthood, and marriage enjoy special statutory protection. I should stress that the word marriage was added to the governmental draft of the Civil Code only later, thanks to the general debate. Therefore, the Book 2 of the Civil Code protects only family based on marriage. So family law regulated by the Czech Civil Code is very marriage-centric. Regarding the people of the same sex, they are allowed to enter only into registered partnerships, and the rights and duties of registered partners according to this act are very limited. We can say that the act is empty regarding the rights and duties. And regarding people who don't want to get married or registered, their legal protection is even more limited. And if there is no contract between them, they are simply not protected at all, especially the single mother with the child after the separation or the death of the child's father and so on. It creates a lot of problems. And perhaps surprisingly, public law respects the constitutional values more and supports our families by public law measures, tax law, social security law, state benefits, and so on. There is no discrimination against parents of children born out of wedlock or against those children. There are some exceptions, for instance, as regards pension law. For example, the widows and widow's pension are intended only for a surviving spouse. I will give you details later. Here, you can see the concept of marriage. I'm not going to read all the rights and duties regarding the personal rights and duties. They are traditional, so no surprise they are regulated like you can see. And regarding property, rights and duties of spouses, I would like to stress our marital property regimes. It's community property. And very often there are no contracts, no agreements between spouses or spouses to be, so the statutory regime applies very often. And it's a very broad concept. It's very pro-family concept because the statutory regime includes what one of the spouses has gained or what both spouses have gained in the course of their marriage, with some exceptions, of course. So this concept protects the weaker, very usually the women with children, and not only during the marriage, but even after the divorce or the death. For instance, regarding settlement after the division of property, only even qualitative measures are taken. So, for instance, interests of minor children are taken into consideration. So it's not 50-50, it can be in a different measure. And I would like to stress that there is a statutory protection of the family home. For instance, a common tenancy of a flat by operation of law, the concept of movable things forming a common household, and so-called prohibition to dispose of the family home against the will of either spouse, family needs, and so on. Of course, there is maintenance duty, and after the death, the concept of pensions. Regarding a registered partnership, as I mentioned before, the act is quite empty. The act doesn't protect family dwelling. We can speak about family, I think we can. There is no community property, and in general, simply this act doesn't regulate partnership, but just concluding and dissolving of the partnership. Regarding de facto unions, the civil code doesn't protect this de facto unions at all, and if cohabitees don't conclude any contract, simply there are no rights and duties, and there are seldom contracts. However, there are special provisions that protect the mother of the newborn child, but the girls, the women don't know about this protection. It's quite a good one, but simply it's not used much in practice. Here I have some pending drafts. I have been spoken about these pending drafts for years, but still they are on the table. Perhaps I would mention the let's say, progressive one. So the draft, the draft calls for the marriage for all, and if it would be passed, simply not only men and a woman, but two men or two women could conclude, could enter into marriage. But regarding parentage, it would remain the same. The child could have only one mother and one father, and simply it would be traditional. So this change, if it would be passed, if it would be passed, it wouldn't bring many changes, and especially regarding the children, there would be no significant. I would like to share with you something new. We have new pending drafts. There are new pending drafts on minor children. They are connected with autonomy of will and with freedom. So, at the first one, regarding divorcing parents, the Czech Civil Code provides that the condition that if the married couple has minor children, the judgment on divorce must be preceded by the decision on the relation to the minors for the post-divorce period. And in the case of a post-divorce arrangement of the relationship of the agreed parents to the joint minor children, it's obligatory to approve an agreement on personal custody and maintenance, or optionally on visiting rights between the child and non-custodian parent by the court. The proposal, its aim is to make the situation of divorcing parents of the minor child equal, or at least similar to the position of the non-married parents of the minor child who separated without any interventions by the state, thanks to the mutual non-formal agreement. So the pending draft is based on the opinion that the parents of the minor child know their child very well and seek to follow the best interest of the child even when separating. So should the draft be passed, the divorce of a husband and wife who can agree on the divorce itself and on property and valid consequences of divorce and on post-divorce arrangement regarding the minor children would be amicable, smooth and quick. The divorcing couple would have to submit to the judge only the common motion for granting the divorce, the property and wedding contract, and the agreement on minor child regarding custody, maintenance, and perhaps visiting rights. The judge dealing with the divorce wouldn't have to approve neither the property contract nor the agreement on custody and maintenance towards the minor children. The situation would be the same as for unmarried cohabitation. If there is an agreement between the parents, the court will not approve it. Often, the agreement is quite informal. Therefore, parents do not use legal categories such as sole, alternate, or joint custody for the period after their separation. That is why the second parliamentary proposal aims precisely at removing these formal categories of personal custody. So I wonder what you think. It should be emphasized that under Czech family law, both legal parents of a child are holders of parental responsibility and are entitled to exercise the partial rights and obligations arising from this concept. So Czech legislation should be, let's say, similar or the same for formal and non-formal let's say, couples. Here, I have some statistics regarding family and family life. Have a look at this chart by the Czech Statistic Office. based on accurate statistical data. So I have 4 minutes.
Yes.
Okay. You can see the proportions of children born out of wedlock. It's almost 50%, which is quite a lot. Although we have quite low natality. And I would say that these numbers don't say anything about the family life. We don't know if the single mothers live alone with the child or with the fathers or with other people and so on. But it says something, and that's why family support and family benefits are designed for all families. So I would like briefly concentrate on the current legislative pillars of Prof family policy. And as I said at the beginning, perhaps surprisingly, public law respects the constitutional values and protects all the families or the kinds of family life. And first, perhaps I would mention the concept of maternity, paternity, and parental leave. It's regulated by the Labor Code. To give you some data, perhaps I would say that the mothers can stay at home. They can take they are allowed to take maternity leave for 28 weeks. The fathers can stay with the child for 2 weeks, and parental leave shall be granted to the mother or to the father for 3 years. The concept of maternity allowance is regulated by Czech sickness insurance system, Sickness Insurance Act. And for instance, I would say that it makes 70% of the daily assessment base. So depends on the income of the woman she had before she delivered the child. Regarding other financial support for families, they are regulated by a number of other legal acts, and some are income-related, some not. For instance, when a child is born, the parents are entitled to a childbirth allowance, but it's not for all, depends on incomes. And to give you an idea, I don't think we have a good family policy. Yeah. So the amount for the first child, if I count it well, is 500 euros. And for the second child, it's only 400 euros. Nothing for the third and so on. So only 2 children are relevant. So it's the state policy. Well, then we have child benefits. They are regular. It's a regular support for lower income families. And from the webpage of the Ministry of Social Affairs, I found out that the amount of the allowance ranges from 30 to 60 euros per child per month. Yes, and then we have parental allowance. They are designed for all parents, and altogether it's 12,000 euros, which can be divided into 3 years. So it depends how long the parents stay at home with the child. So I will. The system is quite complicated, of course. The Act on Income Tax counts with family members. Let's say simply, for instance, there is the spouse discount or tax credit, if I translated it well. And quickly, we have, new family policy, but it's political issue, I would say, so I'm not going to read it. And conclusions, of course, there are a lot of problems. We face a lot of disadvantages, but I just would like to say that thanks to the COVID, perhaps lockdown, we have more children than we used to have. For instance, in the year 2000, the natality was only 1.1. At the moment, it is 1.7, so more than last year. So we will see how many children we will have in the future. But I don't think that the increase is due to family policy. It's perhaps lockdown and so on, which help the increase. So thank you for your attention. Thank you for having me.